submits on instruction.
If something is deposited in the credit ledger, automatically
It will be adjusted.
it will be adjusted to the government exchequer.
Or it will be appropriated. So that is why lifting is to be done.
I have to pay if I file a return. I have to through PACL. I have to pay at
আচ্ছা তাহলে ওই clarificationটা দিয়ে দিন so that it is easier. It is submitted by Mr. আর এখানে লিখে দিন a copy of the instructions handed up to court by Mr. কি ছিল 20 দেখি not today. Next.
I'm for the question.
Yes.
Well, petitioner made purchases from one melon mid-integrated steel of Odisha melon during the month of August, September, and October melon. Now, my lord, that supplier filed its return showing outward supply in GST at 1 melon. And as a result whereof, my lord, it was reflected in my GST at 2A. My lord, I claimed the ITC and availed the ITC on said purchases. Thereafter, my lord, the department issued one so-cause notice saying that since there is a mismatch, since the supplier has not filed its return in GSTR 3B, meaning thereby, my lord, he has not paid the tax on the supplies made to you, so you are not entitled to ITC for the month of, my lord, July, August, September, October on inward supplies received from the same, my lord, Mid-East, my lord. My lord, after during the pendency of this so-cause notice, this proceeding under section 73, my lord, the supplier filed the two returns for the month of August and September.
And it paid the tax.
And he paid the tax. My lord, the return can be filed only when the taxes are paid, my lord. Now, my lord, on the basis of my submission, and my lord, they verified that the supplier has filed the returns, the authority allowed the ITC to the tune of rupees for the month of August and September. And for the month of October, since he has not filed the return, my lord, it was disallowed. And a demand of rupees, my lord, 16 lakh and on was raised, my lord. Now, my lord, thereafter I filed an appeal. Appeal was only on the ground that if the supplier files the return, it will be allowed. The appellate authority will be allowed. Appellate authority will allow. My lord, after filing the appeal, my lord, hearing took place, and the only point of dispute was that the supplier has not filed the return for the month of October, so ITC was disallowed.
So the
In the
subsequent
meantime,
filing of
subsequently, during the pendency of appeal, my lord, the supplier filed the return for the month of October.
that was brought to the notice of the appellate.
It was brought to the notice of the authority, my lord, appellate authority. He recorded that it was filed. But now the authority, my lord, appellate authority disallowed my claim of ITC on a new ground, my lord. One ground is that I fail to prove whether the transactions which has been effected by the supplier with me, taxes were paid on that particular transaction or not. It was not within my control. My limited responsibility is to show that the supplier has shown its supply in its GSTR 1 return, and it was, my lord, flowing from there, it was flowing in my GSTR 2A, and he has filed the GSTR 3B return. Because GSTR 3B returns, if it is filed, my lord, the liability is
In any
discharged.
case, on this new ground, you were heard by the appellate authority? or-
No. And thereafter, my lord, he says that I have to produce the documentary evidences whether I am entitled to get the ITC or not. That was never asked by the appellate authority, my lord. This was only ground, my lord.
So today morning only, Mr. Rai was showing that provision of 107(11).
Yes.
That if a new ground is
Yes.
to be taken, then
Or new liability is required to fasten, then he has to give me an opportunity.
he taught me in the morning today.
Yes, it's 107.
So I am applying that.
Yes. My lord, now kindly see the order, my lord. First, my lord, kindly come to the adjudication order, my lord, at page 32, relevant paragraph, my lord.
Page 32.
It starts with from page 29, and the relevant paragraph is page 30, at page 32. my lord.
32.
Just before the table, my lord, last paragraph. Considering the request of the RTP to wait the supplier till he, that is, my lord, Mid-East suppliers, files return, no further action was taken in this regard. Since the issuance of so-called notice, the supplier had filed its GSTR 3B for the months of August 19 on 11th January 2021 and September 19 on 13th April 2021. However, no further GSTR 3B for October has been filed.
So for those 3 months,
Out of 3 months, 2 months he
2 months,
considered.
yes, August to September, 2 months.
Yes.
Sorry, 2 months they have reduced.
They have
But
reduced.
by the time the adjudication order was passed, October 2019, GSTR 3B was not
filed.
So this came to be filed by the time the appeal was considered.
Yes.
Appellate authority did not consider.
No. My lord, kindly see the appellate authority's finding, my lord. It starts from page 51, and the finding of the appellate authority is at page 57, my lord.
57.
He records the, my lord, the relevant provision and all these things. My lord, kindly come to page 60.
Page 60.
Thus, as per sections, my lord, last but
Yes.
third paragraph. Thus, as per section 16(2) subsection clause C of the CGST WBGST Act, no registered person shall be entitled to the credit of any input tax credit in respect of any supply of goods or services or both to him unless the tax charged in respect of such supply has been actually paid to the government. You know, thereafter he quoted the judgments. Now, page 61, last paragraph C. The RTP requests for the setting aside of the order passed by the department since the said supplier had duly filed their October 19 GSTR 3B on 19th May 2023. The entire demand along with the interest and penalty should be dropped and the amount recovered against the impugned order must be refunded to the petitioner. The instant appeal is being filed within a due date as per the notification number such as such. Again, these submissions are mere bold submissions, statements of the appellant, as he has failed to show with suitable evidences as to where and how the appellant satisfied the conditions specified in section 16 of the Act in tandem with the quoted circular properly and within due date prescribed in the statutes. Thereafter, my lord, kindly come to last
And,
paragraph.
Mr. Dugar, what is the show cause? Please show me the show cause once.
So, cause notice or your lordship will find.
Page 22.
Yes. My lord, page 21. My submission was recorded, my lord, thereafter in reply to the notice in form, last but second paragraph. GST DRC on send a reply on such and such wide reference. The RTP has claimed that as the GST registration of the said is still active, which clearly indicates that the said supply is still existing and doing business, and there may be departmental correspondences with them for collection of the revenue. MISL Odisha has filed the GSTR 1 up to the December 2019 and GSTR 3B up to July 2019, and no further GST returns have been filed by MISL Odisha. MISL has passed on the ITC commit by filing GSTR 1 for the period from August 19 to December 19. However, no corresponding payment of taxes for this period has been made by MISL, and no GSTR 3B have been filed for these 5 months. Whether MISL Odisha is an active taxable person is not in any way related to the claim of ITC.
Page 20, Mr. Dugar. Page 20. First paragraph.
First paragraph, my lord, yes.
Last line, last 3 lines. However, Mid-East Integrated Seals Limited have not submitted its GSTR 3B for the period August
Yes,
19 to
yes,
this was the
yes.
point.
This was the only point, my lord. And my
So
lord, on
it
the
has passed on the input tax credit by filing GSTR 1 for the same period.
and there were 3 months, my lord, there were 3 months in dispute. Out of 2 months, when the said supplier has filed the return, the authority allowed the my lord, the claim of the ITC for those 2 months. And for 1 month, the only ground was this, my lord, that the GSTR 3B was not filed by the supplier, my lord.
Yes, and what has the appellate authority thereafter done?
Thereafter, my lord, kindly come to page 62.
Page 62.
Yes. Last paragraph, my lord. Most importantly, as per the information made available with a mail dated such and such from the information system division of our directorate, consequent on the requirement of the undersigned as to whether the supply of 1,06,17,440 as per the invoices as alleged ensnared in the GSTR 3B of the supplier had been made to the recipient appellant or not so as to ascertain as to whether the requisite tax has been paid to those invoices. It has come to the Fourth, that the invoice-wise details cannot be downloaded from the GST back office portal, as the GST 2N belongs to other state which stood cancelled suo motu with effect from 5th July 2023. That is much after my transaction effected in 2019. Additionally, the appellant has failed to produce any records at this stage to bear out the fact that those auto-populated invoices were duly incorporated in GSTR 3B of the MISL and due tax thereof had been paid to the state exchequer as mandated in the statute. We must not lose sight of the fact that mismatch between GSTR 1 and 3B of the same RTP is a phenomena in the real politic of the GST legislation and reconciliation whereof yields a substantial amount of revenue, and in case in hand there is no guarantee that the taxes had invariably been deposited by the MISL on the quoted invoices auto-populated in GSTR 2A of the appellant. The RTP has failed to provide any evidence from which it can be ascertained that the suppliers have paid the tax to the government on those supplies which are not disclosed or admitted by the suppliers in their submitted returns in GSTR 1. Most importantly, the appellant has failed to produce any evidence testifying the fact that he has actually received the goods. Well, this was not the finding, because he has, my lord, disclosed the supply in its return in GSTR1. So we have received the goods, my lord. And the so-called notice issuing authority never disputed that we have not received the goods. The only ground of disallowance of the ITC was that he has not filed his return in GSTR3B. Now, new points, my lord, there is no whisper.
Actually received the goods, all these things were not there.
No. The only ground for disallowance was that the supplier has not filed the GSTR3B return. This was the only ground. And subsequently, my lord, during the pendency of the appeal, he has filed the return. Now, my lord, what the appellate authority's grievance is, my lord, that since I could not produce any transaction-wise detail as to whether the tax has been discharged on that outward supply or not, so it cannot be allowed. My humble submission, my lord, GSTR 3B contains one figure, my lord, regarding outward supply, and GSTR 1 bears the detail of the entire outward supply. So if both the figures are tallied, my lord, because the total outward supply is disclosed in the GSTR 1 as well as in, my lord, GSTR 3B. So if both the figures are tallied, then automatically the tax has been discharged, my lord. And there is no finding that there is a mismatch between the GSTR 1 and 3B of the supplier. Well, several judgments, my lord, and the legal maxims were quoted. Well,
Yes, Mr. Chakravarti.
Yes, ma'am. I would kindly come to first question.
Yes.
Page 20.
Page
29.
20.
20.
The paragraph starting with section 20.
Paragraph starting with section. Yes.
Section 20 of the IGST. So 17 states are subject to the provisions of the IGST Act and the rules made by the provisions of the GST and with the input tax shall immediately apply. So starting with section 16. Section 16 of the GST is the condition of taking input tax credit. Section 62C of the system that no registered person shall be entitled to the credit of any input tax in respect of any supply of goods or services or both unless the tax charged in respect of the supply has been actually paid to the government, either in cash or through utilization of input tax credit admissible in respect of the same supply. Hence, the article is not entitled to claim input tax credit. Well, this was the ground was there, but subject to correction. It is nothing. It is not something a new point was taken. The ground was there.
No, but this was the ground.
Yes.
Hence, the RTP is not entitled to claim
No
in
question.
tax credit in respect of the inward supplies from Messrs. Mid-East Integrated Steels Limited for the period such and such to such and such. Why? Because
He has not.
under section 16(2)(c), no registered person shall be entitled to take credit of any input tax in respect of such and such unless the tax charged in respect of such supply has actually been paid to the government.
Actually, been paid. But
Yes.
now kindly see 16(2)(c). That is the provision, madam. Because madam, 16(2)(c), the liability, the burden of proof is only for claiming ITC. Burden of 155, that is 60. Subject to the provision 16(2)(c) of section 41, tax charged in respect of such supply has been actually paid to the government. Well, that he has to show, he has to discharge this burden. That actually the government has received against that particular such transaction. That is my understanding of the provision. Now, madam, in view of this consideration, madam, his supplier has filed subsequently. I say it does not reflect the actual transactions. The sum and substance of my saying of pages 62 and 63. Whether, madam, that is not a valid ground or not. Well, this is a case where he is claiming ITC. But if madam says every registered person, the 16(1) starts shall, subject to such conditions and restrictions as may be prescribed, and in manner specified in section 49, be entitled to take credit of input tax charge. So restrictions and conditions. Both has to be, he has to discharge. And today my learned friend says my supplier has filed subsequently. But the supplier, but we are saying that the transactions doesn't match. Because when that's something new.
No, are you saying that the transactions don't match?
Well, yeah,
Or you
but
say
can
that
it
he
be,
has
can
not
it-
been able to?
Not in so many words. Because what this is.
And kind, in
Dada,
so,
I don't know that. Because this cannot be considered as a new ground. Can we consider this? Because this 3B has come at the stage of application. So 107.11 will not be applied here. Because my opportunity to
No, 107.11 doesn't say that it cannot be it cannot be treated to be a new ground if the new ground is based on a subsequent fact.
I go to
107.11
what extent it is
definitely.
my learned friend who is showing this.
Yes,
3B is shown by my learned friend that my supplier has now filed. I'm considering this. So when I notice everything is there.
the idea is that what is crossing the minds of the
But
appellate authority
the
must be
equation
made
should be there before
must
the-
be made
but-
known to the RTP so that he can reciprocate.
But I would now just kindly come to 62.
No, but what is your answer to his explanation? He says that GSTR 1 will have all the details of the supplies,
yes,
category wise details of the supplies.
bill wise,
Now, GSTR 3B contains the total.
total.
Now, if the aggregate of GSTR 1 matches with the figure mentioned in GSTR 3B, which is cumulative in nature, then in that case, you are only concerned with the tax
we have
discharge
received
of tax liability.
Yes, absolutely.
All the transactions which are showing in GSTR 1 have a figure. The cumulative effect of that figure is matching with the total which is mentioned in GSTR 3B. How can you still say that tax liability has not been discharged?
I would kindly I cannot improve on the findings. 62 minor would kindly come to page 62.
Page 62.
The para starting from the last para, most important. As per the information made available, mail dated so and so from the information system for detected, consequent on the requirement of the understand as to whether the supply of so and so, as per the invoices allegedly of the supplier has been made to the recipient applicant or not so, as to ascertain as to whether the requisite tax has been paid to those invoices. It has come to the fore that the invoice wise details cannot be downloaded from the GST back office, as the GSTN belongs to other states to cancel suo motu with effect from July 2020. And that's why we had asked him to produce the documents. Kindly now see. Additionally, the applicant has failed to produce any record existing to bear on the fact that auto popular invoice were duly incorporated in GST of MS and due tax thereof has been paid to the state exchequer as mandated in the statute. One of difficulty, these are all IGST transactions, interstate transactions. But the proportion to the state will not get it if we do not have the information.
Yes.
But this is the statement. But this is where we could not get the documents we had asked for him to clarify. And Manoj, he had to produce the documents. It is his burden of proof. Manoj, can you see section 155? 155. not a wasted right, subject to correction. It's not a wasted right. This is where any person claims that he is eligible for input tax credit under this act, the burden of proving such claim shall lie on such person. Today, a transaction has taken place. He has satisfied the adjudicating authority that this 2 months. Now, at the stage, we are not getting the details. We do not know what against which taxes he has, and it's an interstate supply. Because we will be entitled to an apportionment of the taxes. So, I have to clarify it, or the state exchequer loses, and that clarification did not come from my learned friend. If he can produce the invoice, then can matches the document with CV, because we are not getting the details. That is the specific findings of the appellate authority, and my learned friend has not disputed that.
Yes.
Well, may I submit one? We have provided the GSTR 2A. This GSTR 2A was available to them also.
GSTR 2A is for what?
GSTR 2A, my lord, the supplier files its return in GSTR 1, showing his outward supply. And GSTR 2A is auto-populated on the, my lord, in the login account of the recipient, that the supplier has shown its supply to you. So, my lord, these transactions were reflected in GSTR 2A. So, the supplier has, my lord, admitted that I have made the supply to you by showing it in the GSTR 1. And those figures were available to the department, my lord, because the so-called note, the appropriate adjudicating authority has allowed the claim of ITC for the 2 months, my lord, on the basis of the GSTR 2A and thereafter, my lord, 3B, filing of the 3B. Now, my lord, 3B does not have the detailed figures of the outward supply, details of the transactions relating to the outward supply, my lord. It is only reflected in GSTR 1. GSTR 3B contains, my lord, only the figures of the outward supply, total amount of outward supply which has been effected by the supplier. Now, my lord, what is my responsibility to prove that how the onus can be discharged? Man? I have to show that this is the GSTR 2A wherein the supplier has shown the outward supply to me. And thereafter, my lord, GSTR 3B, he has filed its GSTR 3B.
Your GSTR 2A will contain invoice-wise details.
Invoice-wise detail, but my lord, this will contain only to the extent relating to the supply made to me, my lord.
Of course, that
not
is what
all the supply, all the supply.
That is what they are also
Yes,
concerned.
yes.
So your burden will get discharged immediately upon GSTR.
So insofar as the
2A
supply is the concern. Now, next issue comes, my lord, that whether the GSTR 3B, which has been filed by reflecting certain figures of the outward supply, whether those figures contains the GSTR 1's figure or not. That is, my lord, beyond my lord capacity, my lord, impossible to prove, because until the authority, my lord, takes the endeavor to get it verified from the concerned jurisdictional officer of that supplier, my lord. It is not within my control, my lord, that as to how I can prove, my lord, that whether in that GSTR 3B it has been disclosed, the liability has been discharged or not. And, my lord, considering this impossibility, my lord, the so-called notice authority has allowed my claim of the ITC for the 2 months only on the basis that the supplier has filed the GSTR 3B. Now, he has taken the different stand that though he has filed the GSTR 3B, but since you are unable to prove as to whether the tax on those particular outward supply has been discharged or not, so I am not allowing the ITC. And, my lord, GSTR 3B can be filed only after the payment of the tax is made, my lord. This is under the provision, my lord, it has been stated. A registered taxable person cannot file the return, my lord, until the tax disclosed has not been, liability is not discharged.
Very well.
So, my lord, would only consider 63 first line. There is a specific finding that he could not find, but this 2A was considered. If my lord sees the last 2 lines of 62, RTP has failed to provide any evidence for which it can be ascertained that the supplier have paid tax.
Page 63?
62 last 2 lines.
62 last 2 lines. Yes. The one which has not been underlined.
Yes, because before that underlined 2A was considered. Thereafter, the RTP has failed to provide any evidence from which it can be ascertained that the supplier have paid taxes to the government on all supplies which are not disclosed. admitted by the supplier in their submitted statement in GSTR 1. Most important, the applicant failed to produce. Well, জানা কোথায় রে?
And moreover, there is no allegation that there is a difference or my lord, the mismatch between the GSTR 1 and 3B filed by the supplier, my lord. If there is no allegation, my lord, the supply has been proved and the tax liability has also been discharged is also proved.
Very well. I'm keeping it on one more day. I'll pass that judgment on that. And in the meantime, I'll consider. I will require some homework.
Yes. And now your lordship may kindly take note of the Suncraft judgment. Your lordship knows that the liability of the supplier cannot be fastened upon the purchasing dealer until unless the department takes action against that supplier, my lord. Though he has paid the taxes.
I cannot take any steps when I can consider this because he is not registered and he is not within the state of West Bengal. But I cannot take a step. It is admitted position when this order was passed. As on that date, this order was 2024, subject to correction.
23rd October 2020.
And his cancellation is 2023. But I cannot do anything. I have to catch him only.
What I am submitting, my lord,
No,
he
no,
could have write a letter to the jurisdictional assessing officer of the, my lord, that supplier as to verify as to whether the tax has been discharged on this particular transaction or not. But straightway he is putting the entire responsibility upon me to prove that whether this the tax has been discharged on this particular transaction or not, my lord.
Just for the purpose of distinguishing Sangram, a copy of the
Reported.
So reported
No, copy the lagbe nahi.
But for distinguishing.
And recently, Honorable Supreme Court has also passed the same order in Arise India's case. Next day রাখছি তো হুজুর
আবার সেদিন 10টা জাজমেন্ট
একটাই সুপ্রিম কোর্ট একটাই তুমি আর 100টা লিখছো
Yes. লিখে নিন। Heard Mr. Dugar, learned advocate, appearing for the petitioner.
My lord, I am appearing for the petitioner.
হ্যাঁ আমাকে দেখিয়ে নেবেন এখনই কাউকে বলার দরকার নেই দেখে পরে যদি থাকে তাহলে শেষ করে দেবো বাকিগুলো কালকে পেন্ডিং রাখি Yes.
My lord, I am appearing for the petitioner, my lord, online, my lord. Last occasion on 1st December, it was.
It is ready, when the concerned officer could not come, kindly keep it on Wednesday. We'll file a report and you have to file the report.
My lord, there is 1 week time for giving reply, so exception, if any. So accordingly, my lord, kindly. They are saying Wednesday, by Wednesday they will file.
Not tomorrow, next Wednesday. By next Wednesday.
লিখুন একটা অর্ডার লিখে নিন মিস্টার চক্রবর্তী learned advocate appearing for the respondent state GST authorities seeks 1 week's time to file a report in the form of affidavit in terms of the order dated December 1, 2025, full stop, as prayed for, comma, let such report be filed by January 13, 2025, 2026, full stop. Exception to such report may be taken within a week thereafter, full stop. List this matter for further consideration on January 21. No, January 22, 2026.
Section number protection.
Obliged, my lord.
So, project কোন ডকুমেন্টের বেসিস করে দেখেছি? But kindly take it up tomorrow. My mistake, I missed this matter. I did not check.
Not today.
জ্যোতিটা
জ্যোতিটা
এটা
कौन सा वाला
কথা বলতে হবে।
2315 32 lordship, that Jyoti tar matters which was heard pre-vacation. We have submitted our written notes also. Some judgments I had shared. I'll just take your lordship to those judgments.
আবার তো judgment
So that is already submitted, but just to recapture your lordship, because certain points are there, then my learned friend can
he had argued.
No.
At the time of argument, he had shown 10 judgments. In the
No.
notes, but he did not
No,
rely on
it-
those 10 He again.
No, lordship, all those judgments were there. Some extra judgments I had given copies. I'll just place those judgments and then my learned friend can argue and your lordship can conclude.
আমার একটা
32 and lordship 37 are same SSC, different periods.
আমার নোটটা কোথায়?
Second 321513 नहीं है.
Yes.
আরো ছিল একটা
89. Lordship, here the issue, I just take 2 minutes to recapitulate, Lordship. We had, this was the second round of litigation. In the first round,
দিদি
show cause notice.
সব মোটা ফাইলগুলোতে অর্ডারের ফাইল আলাদা করবেন, ঝামেলা সব ছিঁড়ে যাবে। ভেতরে অর্ডার আছে নিশ্চয়ই, সব ছিঁড়ে যাবে। না, একটাই অর্ডার তো থাকবে না। কোনটা? আরেকটা কোথায়? কোথায় সেটা?
32 and 37 are, Lordship, same SSC, different period, same issue.
37 হ্যাঁ দেখবি। এটা কি অর্ডার হয়েছে?
Written the submission concept.
Yes.
Lordship, the case was that it was the second round of litigation. Earlier, a show cause was issued challenge on the ground that certain of the suppliers' registration has been cancelled retrospectively, and that means that there was no movement of the goods caused, and therefore my ITC was disallowed. We had furnished a detailed reply. We had given our tax invoice copies, e-waybill copies, and bank statement showing the payment proofs. And there was no per se, because it was transported directly to me, so I did not add any lorry receipt or documents like that, but e-waybill contained the vehicle number. The order came to be passed. We came before the writ court. The learned single bench dismissed the petition. We preferred an appeal before the division bench. The honorable division bench remanded the matter back to the adjudicating authority on the ground that the reply has not been considered properly, and therefore to re-adjudicate. Now, in re-adjudication, lordships, the department started from afresh. They issued a fresh DRC 1A because, as per them, the portal would not allow a re-adjudication on the same show cause number. So they issued a pre-show cause again. We replied. They again issued a show cause, and in the show cause we stated our earlier reply be taken on record because there is nothing more, because all documents are already there. Now, lordship, when they issued again the show cause notice to us, we came before your lordship at the show cause stage on the ground that section 74 cannot be invoked, and the show cause now was as good as an order. on the issue of predetermined. The nature of the show cause, reading the show cause, it was seen that it is as good as a demand order. This is the contents and section 74 for cases wherein RC has been cancelled retrospectively for the since from the date of inception. There is no proof given in the show cause also that on whether there was any connivance between the supplier and the recipient. That was our preliminary challenge, lordships. We had placed the reliance upon various judgment, lordship, and then in my written notes I had given the 4 conditions, lordships, and the 4 conditions to avail the ITC under section 16(2) was recipient must be in possession of tax invoice, the recipient must receive the goods or services, the tax must be paid by the supplier, and I should have filed my returns under section 16(2). So, and under 155, lordship, the burden to prove to get a valid ITC is on me. So I had submitted all the tax invoice which was in my possession. They have not disputed in either in the show cause at all. I had submitted movement proof in the nature of waybills. All the waybills contained, all the waybills we have submitted, which contains the vehicle number and the details of movement. All. Not there is no allegation in the entire show cause that you have not submitted waybills or these waybill vehicle numbers are bogus or they are not matching in Vahan system, nothing. Like, lordship, whenever such type of investigation happens, the department also summons the transporters to say, and we also cross-examine them to prove that whether they had actually moved the goods for me or for the supplier for that matter. But there is nothing such, no investigation of that nature, no allegation to that nature was there in the show cause. Thirdly, lordship, tax must be paid by the supplier. We had given screenshot of the GST portal showing the return filing status of all the suppliers, 4-5 suppliers alleged, which has shown that the period which is in dispute, all the suppliers have duly filed GSTR 1 and 3B. 1 means, lordship, their outward supplies, 3B means their tax payment. There is no allegation in the entire show cause that they have not paid this tax. Merely RC cancellation without first doing any recovery, without giving me this information whether what they have paid. Either they could have filed a nil return. Suppose in GSTR 1 they have shown a supplies because it is auto-populating in my inward register, lordship, in the portal. GSTR 2 it is auto-populating. That is why they have got this information. Had, lordship, the supplier shown the return, shown the supplies as unregistered to me, not reported under my GSTN, it would not have been auto-populated under my name. The department would have never be able to make a case because the supplier is only showing one-way data. He reports that as B2C. So the entire data of the department is that because it is auto-populating in my 2A, that means I have taken input tax credit for certain suppliers who are deemed to be non-existent or who have taken registration by unlawful means. But in the entire show cause, there was no allegation as to whether they have not paid the tax. To me, the burden of proof under section 155 is to prove that the ITC is eligible. Eligibility is defined under 16(2). 16(2), lordship, gives us 4 conditions. Tax invoice should be in possession, movement of goods should be proved, tax should be paid, and I should have filed my 3B. Out of the 4 conditions, which condition I have not proved? They have not stated that. They stated there is no evidence to show the movement. As an SSC, lordship, as a taxpayer, my only evidence is an e-way bill. Because e-way bill, before any movement is caused, the supplier or the recipient, whoever causes the movement, has to prepare a e-way bill, upload from the department portal. It is not that I prepare e-way bill from my ERP system. I prepare it under NIC portal, which is a departmental, like the GSTN portal. Similarly, there is a e-way bill NIC portal, which is accessed by department also. And those transactions are reported before the movement initiates to the department. The entire show cause, there is no allegation that how I have not received the goods. I have given my proof. Tax must be paid by the supplier. I have given the proof of their screenshot, which at best, at my end, I can access. They can come up with an allegation, no, he has filed a nil 3B. He has not paid the tax, not a single item of allegation in the entire show cause. And lastly, Lordships, at the time when these transactions were entered, the suppliers were registered. They have, in the entire show cause, they have not given any finding as to the reason why they have cancelled retrospectively. They stated because they could not find them in their place of business. But who had given them registration? It was the same department who had given the registration. It is not the case that they've had, Lordship, they have transitioned from VAT regime to GST regime. They have not made out any case. And over and all, with this, they have invoked suppression. They say you have suppressed these facts. For the same SSC for next financial year 21-22, they have issued similar show cause under 73, which is returnable before your Lordship on 17th of this month. And for 2 financial years, they take 74 route because it is becoming time barred. 74, 18, 19 had already become time barred. Just to safeguard themselves from the embargo of section 73, they issue a show cause under 74. No,
This is a, with deepest respect, we are in the stage of show cause. We are not dealing with an adjudication order. Whatever the submission is on the merits of the issues. But before the stage of show cause,
Let him conclude.
That is why I have challenged the show cause, Lordships.
Conclude.
Lordship, I am concluding. And lastly, Lordships, why I say it was predetermined. Now, I had filed a reply to the pre-show cause notice, which they have taken into record. Now, each line, each paragraph that they take into record, they have repeatedly said that you have not provided any GRN document, any payment slip, under which statute, under which law these documents, private records are to be maintained. As per department, they have not given that. So therefore, I say the person who has issued the show cause notice has already made up a mind that because these documents are not there, it is a transaction in sham. And the documents which I have given, why payable will not be relied upon, why the 3B filing status is not being relied upon, has not been dealt with at all. And in this line, Lordships, I had the judgment which was already on record. After that, Lordship, in my written notes, I had given 3-4 judgments, which was latest judgment was of the Honorable Guwahati High Court in National Plasto, Lordships, wherein the Guwahati High Court had read down section 16(2)(c). Lordship, the law as it stands today, if any High Court in the country reads down or declares any provision ultra vires, unless a contrary has been made, it is applicable throughout the country. So there also the Guwahati High Court had held clearly that unless you prove a connivance or you prove that this transaction were entered knowingly and there was no movement of the goods with e-waybill in presence, the question of no movement of goods does not arise at all at this stage. Okay. And one more judgment was, Lordship, in the VAT regime, latest Supreme Court had, following the Arise India on 9 October 2025, that was also relied upon earlier, wherein under the Delhi VAT Act, similar provisions were there. The matter travelled from various stages and reached the Supreme Court, when the Supreme Court affirmed the judgment of the High Court also, stating that mere retrospective cancellation.
Roshan Sharma.
No, Roshan Sharma, Lordship, was just the interim order, which is
nothing has happened.
Which one?
It is just a notice issued matter.
Which one was that?
Lordship, this was
Shanti Kiran.
Shanti Kiran, Lordship. Shanti Kiran. I told Lordships. I told that day, Lordship, that matter.
Notice was issued. No?
Notice was issued by the.
Thereafter, we had appeared, the state had appeared, but I'm keeping a track. That's why
Affidavits. And Lordship, a coordinate bench judgment of this honorable court in Asian Hotels, similar facts, which your Lordship in the morning extended the interim orders also. That all those judgments I relied, wherein the court has given protection on the ground that mere retrospective cancellation cannot lead to denial of ITC. Okay. That's it. And my written notes are on.
My Lord wants me to reply to the factual issue. That's only the judgments.
I just wanted to bring
Recapitulate.
nothing more.
Okay.
You have not given me judgment before, and I had given before. Lordship, I am always fair. I have given judgment before.
5 chartered accountants.
You have the entire state.
Might kindly see the Guwahati judgment. The which one it is?
National class two, no?
Uh-huh. National Trust.
Given.
Might kindly see the last 2 lines of that paragraph, first paragraph. While it was categorically held that a particular purchasing dealer cannot be punished for the act of the selling dealer in case the selling dealer had failed to deposit the tax collected by it. Now, kindly come to the paragraph 7, last portion.
7.
Yes, page paragraph 7. Now, having gone through the above referred judgments, we are of the view that the controversy raised in this batch of writ petition is squarely covered by the decision of the Delhi High Court in the case of so on. Hence, the show cause notice is impugned in the present writ petition and the consequential orders are set aside. However, the department is free to act in those cases where the purchase transactions are not bona fide in accordance with law. But they had given a permission to act in cases where it's not a bona fide. Our case, it's a malafide transaction. Well, first judgment. Well, the second judgment, I don't know why it has been shown 2024 volume 129. Yeah, commercial arising here.
Arising because that was relied in.
Now 9711. 9711. अरे स्टेट ऑफ महाराष्ट्र तो मेरा नहीं है
State of Maharashtra, ठीक है उनको दीजिए ना
मतलब पैराग्राफ all these cases fraud vitiates everything has been accepted by the courts. It's a case of 74.
Para 6.
Para 6 kindly say. It must also be noted that the learned advocate general appearing for the department before the High Court stated that the genuineness of the transaction between the registered dealer and the respondents was not in doubt.
Noted.
Now the Bombay High Court,
We'll come back after this.
yes,
Yes.
Yes.
My lord, the next matter, my lord.
When?
My lord keeps it on next Tuesday.
14th, 14th, that's the Wednesday.
14th, Wednesday.
There is some urgency to lordship at the time, subject to lordship.
As your lordship.
I'll upgrade it as an urgent matter.
Anytime. Wednesday, anytime, subject to lordship. Next Wednesday.
Next Wednesday means 14th.
12 p.m. madam.
12, 11, whatever.
It will appear as an urgent matter. You tell me if you are not in, any of you is in difficulty, then in that case
We'll do it. We'll do it. We'll do it.
Item 33. That order record. আর লিখতে হবে না আর্জেন্ট ম্যাটারে আপনি লিখে দিন
Urgent matter.
Any.
We'll come back after.
It